Okay. So where do we stop in terms of the arguments yesterday?
Few questions were raised as to why the retailer was not sued, why the waiter was not sued, and why only the we were also asking, like, in cases where it's not specifically the fault of, like, this question came up that where it's specifically not the fault of the manufacturer, why is the manufacturer only being made liable? You said that there are economic reasons behind it because manufacturer is the only person who...
Correct. Anybody read up on that? The thing is, remember, in our courses when I was at the National Law School in Bangalore, we had out of 30 faculty about 5 that were decent. The rest were all crap. Right? Now what we would do is, at least in the courses that we were interested in or even disinterested in, the ones that we were disinterested in, to make it interesting, we would hijack the discussion. Right? Which means pretty much 2 or 3 students would take the lead, come up front, teacher's not that great, but take over the discussion. It's a great strategy, it worked very well. Right? And typically teachers that may not be able to communicate to you effectively and teach you effectively, they're more than happy, some of them, to take a slight back seat if they see that anyway the student discussion is running, because it's less headache for them, right? I mean, the class is under control, you don't want an unruly, uncontrolled class, so it worked out. In the subjects that we were interested in and that engaged us, again, we made sure that at the very least we went back, read up on the stuff, came back, etc., etc. So we took it one level higher. So effectively, if you're learning from a bad teacher, you got the fundamental basics at least. And if you were learning from a good teacher or a good class or something that sparked your interest, you would take it several notches higher, right? So one of the things is, whatever you learn in class, if it sparks your interest, please go back and look it up. That's how you learn. Don't sit and take everything, just swallowing it down and saying that, yeah, gyan mil gaya, ab theek hai. It's not the way law works. Go back and engage with it. Any point of discussion that was here that sparks your interest slightly, go back. Figure it out. Look a little bit, look it up a bit more. Study it a bit more. Investigate it a bit more. That's how you internalize. Internalization is what? Is not committing something to memory and then sprouting it out for the exam and then forgetting about it. If you forget about it, chances are you've not internalized it. When you internalize something, it goes up somewhere deep down that you'll never forget it for life. Right? And that's what you should do with legal fundamentals. Our professors we had a very good professor in corporate law. Of course, at that time we thought he was nuts, because all he would do was teach 1800s case law and 1900s case law. No SEBI, nothing advanced. Lee versus Lee, Salomon versus Salomon. But drilled it so hard into us. We internalized it so well that none of us forgot it for life. I don't do corporate law, but I still remember those cases. And it comes in handy. We're going to do Aadhaar today, right? I'll give you a simple story. Aadhaar was done as part of our public interest work at IDIA. Because we have people that fund IDIA for its public interest work. And one of the funders came and said, "Is there something you can do about Aadhaar?" I said, "What's there to be done? There's already something in the Supreme Court." He said, "No, but can we intervene there?" I said, "Why intervene? I mean, there are too many people there. Right? It's a crowded market, and all the arguments have been made, at least to the best of our knowledge, and this is not an area of expertise, at least for me personally. So from the bare fundamentals that I could make out from what was being filed in the Supreme Court, pretty much all the arguments were taken on constitutionality. I mean, and I said, filing for the sake of filing, just for establishing a presence out there, is not something that we do. We go into areas where we want to make a difference, right? We don't go in for the fame and the glory and the name and the, like I said, no CV value, right? We're going if there's a gap, we can make a difference. And here, I said we can't make a difference. But the donor kept pushing and said, no, I think we should get involved now. So we investigated, we said, okay, what's the angle that we're missing here? And the angle that we're missing here is that we have this very astute regulator, the authority, the UIDAI, coming up each time and saying, no breach, no breach, no breach, no breach. Biometrics can't be breached. We've got a 5-foot wall, we've got a 6-foot wall, we've got concrete walls. Right? We're the best researchers. We're the best tech minds. We have people from Pennsylvania. We have Nandan Nilekani who started this. Blah, 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 blah. We know what we're doing. This is a bunch of conspiracy theories. And honestly, at that time, I had another card, but I was concerned about the breaches, but I just didn't know. I thought maybe there might be some truth to it. Maybe people are getting after Aadhaar for the wrong reasons, because people don't like the fact that the state can do a bit of surveillance. So I thought it was state surveillance, primarily that people were concerned about, but were banging it hard because on all counts, so that they bring it down completely. Right? So then, we had, prior to Ishwar, we had another public interest fellow, first public interest fellow, Balu, who just come from Amarchand. And so I sat down with Balu and I said, let's go through these breaches a bit more. There might be an angle there, because at the Supreme Court, they're deciding on the constitutionality. Right? They're only on, is this constitutional or unconstitutional? They're not making Aadhaar pay for breaches. They're not making them accountable. In a constitutionality action, what happens? Something unconstitutional gets struck down, but there's no liability. Right? You walk away scot-free. You've done a whole lot of crap. It's almost like saying, well, there was a genocide, people got killed, and we find that the program is unconstitutional. Oh, so what? Now it can't be done anymore. But what about all the rubbish that they did till now? Did they really mess around with our data? Were they so bad that they compromised things that we hold near and dear to our hearts in terms of our identity information? How well did they take care of it? Are they spinning the media, or is there some truth to the fact that the breaches are beyond them? It could have happened with the best of us. Because no matter what you do in the digital world, there will be breaches. I mean, you can't design a breach-proof system, ever. Right? The smarter technology gets on one side, the smarter technology will get on the other side. When you're a technology security person safeguarding and securing databases, there'll be hackers who are smarter than you. They will come in and hack. Then you up your system again, then they'll again come. As somebody beautifully put it yesterday, what? The cycle. Right? Who spoke of the cycle yesterday? Somebody spoke about the cycle yesterday.
Day before.
Day before. Who spoke about the cycle?
I did.
You spoke about the cycle. Yes, cycle is cyclic. It'll go on, right? You build something, they build something, you build something else. There will be breaches. We're not on the fact that breaches are unavoidable. We're on the fact that have you taken reasonable measures to protect us against the breaches, or have you even flouted that standard, basic standard? That is there a minimum standard for protecting our data that you breached? And if so, you must pay. And then we investigated and said, my God, this is more serious than we thought. The level at which our data was being compromised because of the security architecture was just unbelievable, because it was the weakest security architecture I have seen as a non-technical data person. Phenomenally weak. Why? Because they'd gathered up all these people from across, village level operators and others. Whoever wanted to enroll could enroll effectively. And who are these people enrolling at village level and other levels? People that didn't even have basic equipment. So I started speaking to the journals. I spoke to Rachna Kaira, who was one of the leading investigative journalists who broke the first story on sale of Aadhaar data, right? Pay 500,000, you get access, you go in, you can change any details on any one of the Aadhaar data, you can call up the details, right? These set of access controls were only meant to be with those that could correct your Aadhaar data, but now it's landed in the hand of anyone that pays 5,000 or 2,500 rupees, or 1,000 rupees, or whatever, right? 500 you get access to anyone's Aadhaar details, provided you enter the number. You get the demographic details. And with about $1,000, you get to generate 10 other IDs that you can give out to 10 other people to similarly access. This is huge. Now, Aadhaar comes up as well, there's no breach of our 5-foot wall concrete biometric data. I mean, nonsense. If my democratic data can come so easily to someone who has my Aadhaar number, I'm gone. They can mess around with it. the way people can manipulate data is extensive, unbelievable. If I have data in 5 different pockets, all I need to do is give someone access to those 5 pockets, they will aggregate it, combine it, bang, gone. I can take away your identity in day 1, I can commit fraud, I can do anything else. So I have to be very careful about who and where I give the data and who gets to aggregate and collate the data. And Aadhaar's biggest threat is the fact that it lets you aggregate that data, right? All the different silos come together. The ability to sync the silos, and that's the greatest threat. And for a non-privacy person like us, I never studied privacy before, I didn't care too much about it because I thought, hey, we're Indians, right? I mean, who cares about privacy? Right? I grew up in a family where, 6 of us sleep on the floor on mats. Right here, we share no there are no secrets, right? I mean, everyone's barging into the room at different points, and there's no separate room or anything, right? You could be semi-nude and somebody just enters the room and, okay, joint family. Right? So our cultural notions of privacy are not that. And even on the email, unless you're very tech savvy and others, who cares about passwords? And these are all convenience things. Right? My name is Shamnad. For the longest time, my password was Sham, S-H-A-M. Nothing too complex. You don't care, right? Unless you're sensitized to it. So culturally, privacy didn't mean, but now, bloody hell, it's hitting hard. Because you see what people can do with data. Profiling you. Right? I went to Israel, I got stuck at the airport for 6 hours. They're questioning me and they came up with details about me that even I didn't know. Because somebody had put out something on the web a long time ago, which was not entirely correct. Not entirely false either. But still it compromised. And they had located it. And they asked me the question, and I was like, how do I answer this now? Right? It took me a full 5-6 hours to get out of the Israeli airport. And you can understand why. I'm Muslim. Right? If there's anything slightly incriminating, that's the danger. That there will be information about you that you don't want the rest of the world to know. Private. Because people could misuse it. People could abuse it. And so we said, okay, what do we do? Now we need to make them pay. Because now the constitutional actions are fine, but they've got away with murder. And every time they're spinning the media coming and saying, no breach, no breach, no breach, no breach, 5-foot wall, biometric data can never be breached. These guys are conspiracy theorists. Somebody's trying to bring Aadhaar down. This is anti-national. Right? And of course it helped them because now a French researcher comes in called Elliot Anderson and he starts also tweeting and they say, he's a foreigner. Then Edward Snowden comes and says, there's serious problems here. Your system needs to be redesigned because there's several breaches. Who's Snowden? That's what the head, the BJP spokesperson or whatever, right? And who's this foreign agent? No, we're not concerned about the fact that this is breached, but who's saying it? Huh? We don't care if it's breached, all this data is gone, but hey, Snowden can't say it. Kumar can say it here. And then we said, okay, now let's investigate how to make them pay. So Balu does some research, comes back and says, sir, we can't do anything. I said, why? He said, under the Aadhaar Act, as it stands today, you can't sue. Why? Because the Aadhaar Act says, what does it say? Why can't you sue under the Aadhaar Act? For breaches, privacy breaches.
Only the authority has the power to sue the entire authority and then through them you can.
Sorry?
You can't directly sue them, you have to go to the UIDI, tell them, and then they will start taking things.
So the UIDA has to take action against itself. This is the beauty. Legal ingenuity, right? You screwed up, but hey, somebody needs relief, you have to sue yourself. Is anyone going to do that? I messed up, and I'm going to go and file a complaint against myself. Oh, I messed up. If they do that, what happens? Again, we get hit back with the paradox of the legal system yesterday, which is, are you trying to commit suicide? Why would you sue yourself? Imagine Aadhaar going suing itself and somebody filing a case saying, hey, prosecute them under section 309 or whatever of the IPC because they're actually trying to commit suicide. They're trying to kill themselves. Why would anyone in their right senses go and sue themselves? Or initiate a process where they can be liable? Especially a body like this, which spins and spins and spins and spins in the media. I mean, beautiful spins. I don't know how many of you follow the Twitter feeds, but they're spinning all the time. Right? It's a very solid chakkar, all the time. Pat. And so we said, okay, end of the story. Can't sue, we can't sue, no action, let's wait for the Supreme Court. Then I remembered my torts classes. I said, no. If the statute doesn't provide, there are tort law remedies. No, but doesn't statute preclude tort? Right? That's something you need to investigate post Donahue. To what extent does the statute preclude an old tort remedy? We call it the doctrine of preemption. Does it preempt? Right? And I said, no, they're tort remedies. In negligence, in trespass, that's all fine. But the most beautiful tort remedy, and here, again, it's because we had a moot court, and I remember arguing, was that this is the beauty of common law. The statute says something, the statute places a duty on the authority, and the statute says you are bound by these obligations, but the statute provides no remedy. You can actually sue under common law and say there's a breach of a statutory duty. Breach of the statutory duty actionable not under statute but actionable under common law as the breach of a statutory duty. Are you following? It's an independent tort. Now you know what a tort is, right? A tort is duty of care, I have duties of care, I breach that duty, somebody gets damaged, and I sue. In this, I have a statute, and that statute places certain obligations. The duty of care comes from the statute, but there's no remedy under the statute. So I still show that the duty of care under the statute has been breached, and I need a remedy under tort. You see the beauty of it? And this is the other paradox, the greatest paradox of our Indian judges. They love discretion, right? You know that. Yesterday I was speaking to one of your seniors who just graduated, and she was telling me of the cases that she's handling now. And she said, one of the cases that I'm handling now is about, it's a rape case, but it was settled by the parties. And I said, how can a rape case be settled? It's not compoundable. It's not compoundable, right? Under your, those of you know, criminal law. You can't compound a rape case. Once there's an allegation, the state must prosecute, must be taken to its logical conclusion. Serious offense. You can't settle it. Said, no, it was done under 482. 482 is wide, right? Criminal law. 151 on the CPC, wide. Our judges love discretion, they love doing everything, right? It's like the Kerala High Court. Somebody went there and said, we can't agree on the baby's name. The court said, we'll name the baby. Extensive powers. Somebody went and said, the Kohinoor, our gold, our wealth, you know. Supreme Court said, that's PIL. Somebody else went and said, you know, Sardar jokes. I'm getting very, very hassled. I'm Sardar, and too many jokes about me floating around. Again, PIL. But Dinesh Thakur, India's most famous whistleblower who blew on Ranbaxy and cleaned up the drug regulatory system, goes and files a 500-page petition with all the problems associated with the drug regulatory regime, where our drugs are spurious and are coming to the consumers, and people are eating drugs and or taking drugs and getting their bodies messed up. Instead of curing them, it's killing them. And the Supreme Court says, no, we don't have time for this. We have time for Kohinoor, we have time for this. So why? They love it. Judges, if you talk to them, they love their discretion. But hey, common law they won't touch. Tort law, not common law, tort law. We don't have a tort jurisprudence, much of it, which is why we didn't do too well in Bhopal. And which is why I brought it back to Donahue, because this is an important area of law. We need to get it back, get the spark back in it. It goes to the heart of legal jurisprudence, and yet we don't care about it because the judges don't want to go through the mess of building jurisprudence. Because they've got a jugaad mentality. Right? We saw it in Bhopal. Right? You went, you claimed under different theories, and suddenly one court says, interim settlement. Some 120 million or a couple of crores. Said, how did you come to this figure? No, sounds right. Chalta hai, jugaad. Supreme Court also, even they also arrived at a figure. And said, no, the three figures floating around, we picked one. No basis. So our judges love discretion, but hate to tell you how they use the discretion and what process led them to it. So they're not two thing on. They're not like Lord Atkins in Donahue, building it up carefully, distinguishing it, then bring it. If you went before them, they'll say, no, we'll award damages. What theory are you using? She asked for 500, we'll give her 300. That's what they would have done. It was before an Indian court, and the judge is sensitive, slightly sensitive soul. Says, okay, Mrs. Donahue, you've suffered. They need to pay. 500 manga na 300 de. What theory of legal liability? Yeah. तो पैसा है ना तेरे पास via media, right? So we will not use tort law too much, but because we have so much discussion and we have some good judges, I told Balu, I said this tort will be there somewhere in Indian case. Please locate that Indian case. Some good judge would have applied this tort. And then we found out that there was an aircraft, Air India, no less, the finest of them, the most professional of them. Pilot, co-pilot. Very strict norms of when a co-pilot can take over and under what conditions a co-pilot can actually pilot the aircraft. X number of hours of training, if the pilot is at a disadvantage, very strict norms, all breached. Co-pilot did a landing, a shoddy landing, people got injured. There's a statute governing all of this. When a co-pilot can take over, all breached, but no remedy again under the statute, much like Aadhaar. They went and sued, and the judge said, statutory duty is there, statutory obligations are there. There's a clear set of norms of when a co-pilot can take over. This guy is not qualified, took over at the wrong time, caused injury to these passengers. Statute provides no remedy, but common law provides breach of statutory duty as a remedy, and granted damages under that. So great, put that in. Anyone's read the petition we filed? Mention this case. Remember this case? No. You didn't read it fully. Too long. No? You read it? You read this case? Good. So that's why you need to pay attention in your fundamental law classes. The solutions will not come from the latest stuff. The solutions will come from some old bloody case law that you've never paid attention to. Now imagine if we were in the private sector, I was a private sector attorney, how much money we could have made on this one simple legal argument, right, for a client. We're doing public interest. But when a client came to you and he said no remedy, another smarter lawyer who remembers fundamentals would have said, right, got the client for life. Right? That's why, please, go back to fundamentals. Go to the old case law. Don't disregard them, because they could be an answer to several things. Okay? And that's why it's important to go back to Donahue. Each time, understand it thoroughly, because then you understand the building blocks, you build on it, you can draw upon it much later in ways that you'll be surprised. You'll be surprised. The subjects that you think are not important suddenly become important. I remember when I went for my master's and I was deciding on the last subject to pick, and I was conflicted. No pun intended. But then I ended up picking conflict of laws. Because of the fact the professor seemed good. Rude guy, but he was very good. So I said, okay, I'll pick a subject for the teacher. Sometimes you do that, right? So may not be that interested in the subject, but the teacher is great, so let me go in. And for me, it was just an intellectual exercise. I never knew that it would come in handy at any point in time, simply because, conflict of laws. I'm an IP guy. I do IP. I do a bit of competition. I do technology. For conflicts, okay. Especially if you study conflicts, it can be a bit of a bother. Rome war, double Rome war, triple Rome war. Laws bouncing to and fro. One of your professors yesterday was telling me, William Fox, he said he had an interesting case once on a gay couple that married somewhere and came to India and they wanted a divorce in India. And he said, well, the judgment helped them. Because now what's the law to be applied for divorce? Right? Are they to be divorced under Indian law? Or does Indian law doesn't recognize the marriage? Forget the divorce. Or because the choice of law and conflict laws will be decided on the place in which they got married as a gay couple. Very interesting, right? And if the law of that place has to apply and they can legitimately get divorced under that law, will Indian courts still support it because they still have an exclusion, right? They will not apply a law if it conflicts with domestic public policy. So interesting issues in conflict of laws. I thought, okay, it's intellectually exciting, we'll study it. And then I was still consulting with my law firm while I was studying, Anand in Delhi. And so Mr. Anand one says, it's a very interesting legal problem, we're stuck. It involves some technology and a Japanese company says, can you take a crack? And I said, sure, send it to me. So I came and studied it and I said, no, I think we're stuck. So Mr. Anand said, that's what even I thought. So, I'm going to go back to the client and say, we can't move on this. And I said, hang on, give me one more day. So I'm back, I read it, and I said, hell, why should Indian law apply to this? There is a choice of law issue here. Japanese law should apply here. And if you apply Japanese law, then they get the relief that they want. So we actually got an Indian court to apply Japanese law. Right? It's possible. If it's a choice of law situation, you can apply foreign law. Right? You need to lead evidence of the content of the law. You've studied your choice of law. So all you need to do is go to Indian court and say, this is what the content of Japanese law is. This is the expert that will testify to it. Apply those norms, grant the relief. Huh? Bang. Subject that you never imagined. Coming in handy. I don't know if it actually went to court, but it was an opinion, at least on the opinion. I think we ended up giving the opinion that Japanese law would apply here. Right? Okay, so now give me the arguments. Where are we stuck? You got a cold, Amrita? Huh? Should we regulate the AC a little bit? What do you say? Ah, good.
Sir, should I start?
Yes.
So, after a more intense reading of the judgment, I came up with the notion that the crux of this case is the need for law to venture into uncharted territory.
Mm-hmm.
So, I happened to write, say, 8 or 10 lines that rhyme. So first, do you want me to convince on the argument that why?
Yes, I wasn't convinced with the arguments yesterday, so convince me, please.
Okay. So, Your Lordship, the present case. For the present case, we need to, as we are all aware of the facts of the case. Now, let's see what the precedents and what the established law says. The established law says that for all ordinary cases where there is a manufacturer-consumer issue, then manufacturer would normally be under no duty towards anyone without any contractual relation. And there are two exceptions to this rule. One is the goods being sold are dangerous per se. The other is it is dangerous to the knowledge of the manufacturer.
Okay.
However, the present case deals with such peculiar, such special circumstances that an exception needs to be carved out for goods that are meant for human consumption. which are being sold to public, and the state of affairs is such that it is impossible for there to be any intermediary investigation from the point the goods are leaving the producer's premise and to the point where when the consumer is going to consume.
Where is that from? Where is that from? Which case law?
I am relying on Justice Cardozo's case,
McPherson versus Duke.
yes. So
Does that apply to you? Does it apply? Does it bind me?
it doesn't. However, all the common law judgments of the English and Scots law, they don't deal with the peculiar facts. So,
They don't? What about the mouse in the bottle? That didn't deal with these facts? The mouse in the
Mullen
bottle?
case,
Yes.
In the Mullen case, it is pertinent to note that both in the Mullen and the M. Goel case, those cases did go for a proof, and the present proceedings are we are to proceed on purely.
No, but those cases dismissed even on the legal theory, right? That says there's no theory, there's no liability. So they did decide on the law as well. Mullen decided on the law.
So, in one of the cases, the bottle of beer blasted, and one of the cases.
Mouse, I'm talking about the mouse case.
Yes,
Mullen is the mouse case.
Yes, there was a
Mullen
mouse.
versus Barr.
Now, what happened
And
is,
they said no liability.
however, if we examine the words which the judge has used, as Justice as Lord Macmillan also points out, it seems as if the judge has to go against his own conscience.
Doesn't matter. The law goes against your own conscience, so be it. You're bound by the law, not by your conscience. Under common law, you're not bound by your conscience, you're bound by the law. You're bound by precedent.
However,
Unless you make the argument that this is a bit like the issue that cropped up when Hitler killed all the Jews, right? The Nazi war criminal trial. The interesting question was, can you prosecute the judges of Nazi Germany who sent people to death under a law that existed then? And they applied the law as existed then in Nazi Germany because they were bound to apply the law. And the whole question is, can they be treated as criminals and should they be prosecuted as well? Did they have a higher obligation above the law to apply their own set of morals? That's an interesting question, right? So you're in a regime, the country has a certain law, you applied the law dutifully, now you're being prosecuted because you're saying that, well, your law wasn't you had a higher law, a higher conscience. Are you making that argument, counsel? That this is a bit like...
if we examine Lord Clerk's words in the Mullen's case, the judgment reads such that the judges were forced to reach conclusions contrary to reason and equity. So that amounts to a situation wherein because of precedents being.
Who said they had to decide contrary to conscience and equity?
Lord Macmillan.
That's one judge's view. But Buckmaster doesn't agree with that.
Yes.
Buckmaster says this is inequity and good. He said, why should the manufacturer be liable? As he says, if I can make 5 people liable, now why not 500? So it's one judge's view that it goes against. You have to convince me, why does it go against equity and good conscience? And is it the judge's role to fix gaps in the law? What is the judge's role? Can a judge legislate? Is this, and again, we need to dive off and figure out, is this judicial legislation? Can you legislate as a judge? Can you legislate?
Not legislate per se, but fill up gaps which are
Is there a gap here? Or is it legislation? Is there a gap in the law here or is it legislation?
It's a gap. It's a gap.
What's the gap?
Because
There's precedent telling you can't sue on this, so where's the gap?
not dangerous for both the parties. Like they are not having that knowledge. There were precedent knowing the fact that it can be.
No, no, even in Mullen they had no knowledge. These are all cases where they had no knowledge. Manufacturer didn't have knowledge, and party didn't have knowledge till the time they saw the product. With the dead snail or the mouse, as the case may be.
But was Mullen a precedent? Because
Of course, Mullen was prior to this.
it was decided, not decided.
Why not? Why not? I'm deciding a case, I'm giving a theory of legal liability. Why is it not on merits?
So the theory,
Was Mullen by the was Mullen by the House of Lords? Who was Mullen decided by? See, this is why you need to do your homework. Next time you come up, you have to be familiar. Is Mullen decided by the House of Lords? Because unless it's by the House of Lords, it doesn't bind, right?
So before this,
Unless it's by the House of Lords, does it bind the House? Does it bind them in? Because who's deciding, not you? Now, House of Lords, Superior Court, no bound.
so there is no precedent for this.
That's what I'm saying, man. I'm giving you support for your argument. Is what he's saying is correct. Mullen, you're not bound by Mullen. But are you bound by other case law? What are the other case law? Was there anything else from the House of Lords? Was Heavens versus Pender from the House of Lords? Was Winterbottom versus Wright from the House of Lords? Do those bind you? And was Mullen a mere application of those principles? So Mullen doesn't bind you, but Mullen faithfully applied those principles. And those principles still govern. Okay, reflect on that. We'll swing over back here. Come on.
We are relying upon Winterbottom v. Wright, where it has been said that in the case there is no.
Who decided Winterbottom was right? Who decided? Says who? Says who? Again. Okay, let's assume it's House of Lords. Go ahead.
Yeah.
Why does it bind? What are the facts? What's the ruling?
The fact is that there was a negligence in the construction of the carriage. It broke down, and a stranger.
There was negligence established by whom? Was it a defect or was it negligence? When you say negligence, it must mean that the defect arose as a result of the mere fact of the defect is not negligence. Correct? Mere fact of a defective product, does it mean negligence? What if I employed all the best procedures, like I'm talking about data, right? I did the best data protection measures and yet somebody breached it because he's a superior hacker. Am I negligent? No. Whatever the ISO set of standards then were for security protocols, I followed all of them. So if I followed all of them, then where's the negligence? Was there negligence? Please remember, tomorrow you go before any authority, you cite case law, be familiar with the case law. This is exactly what we're against. The classroom instructional mode. This is what Langdell didn't want. You study law as a set of propositions, but you don't know exactly how those propositions were made, by whom it was made, in what context it was made. You just rattle it without understanding it. So study it carefully, Winterbottom, and then tell me why Winterbottom applies. Any other case?
Yeah, further there is Dominion Natural Gas Company Limited versus Collins and Perkins, where it was said there are two things. For negligence, there should be knowledge of danger that creates an obligation upon the manufacturer, and secondly, if there is a fraud, which is not at all the case here because they is for the negligence. Even if there is a fraud, there should be concealment of that nature of that fraud. So prima facie, there was no knowledge on the part of manufacturer that would create an obligation upon the manufacturer.
Yeah.
And how we draw the theory of negligence is from, like, if there is a negligence, then there should be a liability, and if there is a liability, then there should be a duty, and if there is a duty, there should be a contractual relation to that duty. But when we see that there is no contractual relation at the very outset, then this cannot go to negligence.
If there is no contractual relation, there cannot be negligence. Why not?
Because there is no duty on the part of manufacturer.
Why should duty be dependent on a contract? That's contract law. This is tort law. Why should tort law depend on contract law? Why should the availability otherwise of a duty be dependent, contingent on a contract? If it was anyway going to be under contracts, then why have torts at all? Tort is different from a contract, right? You can't predicate a tortious liability principle on the existence of a contract. If so, then there's no need for a tort. What is the fundamental difference between contract law and tort law? What's the fundamental difference? At its core, what is contract law? And at its core, what is tort law?
Right against every person, and it's not in rem, in contract is personal.
In personam. What does that mean? Break it down for me.
In contract, there can be a right against only one person with whom there is a contract. The privity of contract becomes important there. In tort law, there is a right against rem. It means a right against the entire world.
Okay? Again, break it down more. I wanted to simplify things. Go down to its fundamentals. Ask the fundamental core question. What is it about contracts? Why is it that we want to support contracts?
Limited liability.
And also, I myself have volunteered, no? I myself have volunteered. I have agreed to be subject to this. So the morality of a contract is I myself, I promised. The law is only telling me that, listen, you yourself walked into this. I'm not imposing anything external on you. You agreed to this. You said if you give me 100 rupees, I give you 5 mangoes. We're not doing anything here. We're saying, you please respect what you promised. And as a law, I'm respecting your autonomy. I'm not imposing something on you. I'm saying what you undertook, please fulfill. It's a very simple mapping, no? Morality to contract, personal autonomy, I undertook. Tort is what? It's an external imposition, no? You have to be a reasonable person, one. What if I'm unreasonable? By nature, I'm unreasonable. But no, you have to be reasonable now. For the purpose of tort law, you have to be reasonable. You can be unreasonable. But the moment there's a breach of a duty of care per reasonable standards, you'll be liable. Right? You're the kind of senior, when juniors come, you think the best way of training them is like the Zen master. Master. What's the solution to this? How do I find this case law? Pa! Get it. Suddenly all the citations come up in the air. Right? And you say, that's how I train. That is my methodology of training. It's worked for the last 10 years. But sorry, the person goes and files the case for what? Tort of assault, battery, you name it, no? There's a battery of things you can file under. You can't now come and say, well, I've never been a reasonable person. They knew it. Of course, a little bit of voluntary non-fident area might come in. Who knows? Right? Could run a defense of voluntary also, right? I knew the reputation of this person. This is how they train. I still walked into this chamber. Right? But at the end of the day, it's an external imposition. Remember this. It's a community standard. It's a community standard. Is it community? Right? Reasonable means community. Unless you think the whole community is unreasonable. Can the whole community be unreasonable? No? 377? Majority? Of course you can. The law of morality and the law of standard sometimes differ. But the law of thought standard is of course reasonable man. And the interesting question is, is the reasonable man the majority man? Not even the woman. Right? What standard do you hold them to? That's the interesting part. That's the key difference between thought and contract. So when you break it down, break it down, break it down, break it down, this is how you understand concepts. Break it. Talk to each other. Break it down to its simplest. Any of you seen that movie Philadelphia? Beautiful movie, eh? The patient with the lawyer, extremely smart lawyer, contracts AIDS as an HIV patient, is asked by his law firm, effectively fired from his law firm, and sues. Right? Saying that I was a great lawyer, I mean, I could still have worked and you sued me. Wrongful termination. And you know his lawyer there? Who was his lawyer? Who was the lawyer for Tom Hanks? Denzel Washington. How does Washington start his? Whenever someone's explaining something to him, what does he say? When he wants things to be broken down, what's his classic line there? Explain it to me like I'm a 6-year-old. Right? When I started writing my PhD thesis, my professor told me the same thing. So if you can't describe your thesis in 6 sentences, of course not 6 years, he said 16 years old, to a 16-year-old, then you've got no thesis. Simplicity, break it down, break it down, break it down, break it down. You'll know you've understood something only when you can break it down completely. It's the human quest, it's the eternal quest. Not only in the law and the sciences as well. What do the scientists go after? What's the smallest component? Right? We see a molecule, then we break it down, we see an atom, then we break it down, we see an electron, we see a proton, we see the nucleus, we see a positron. Then somebody like Heisenberg comes along and says, oh well, you know, I don't know if it's a particle or a wave, it depends on the viewer. And then you break, then you come to quarks. And finally when you come to quarks and others, you're not even sure if it exists, because Heisenberg says, well, that thing doesn't exist, it depends on the viewer. And then swish, everything goes, right? Break it down, and you find there's actually nothing. In the sciences. And they're still coming to grips with it. Because maths with ancient Indian philosophy, which is Maya, illusion, everything is an illusion. Then it makes sense. But with law as well, break it down, go down to the fundamentals. Because when you come down to the bare, basic Grundnorm fundamentals, then you know you've understood it. You've really grasped it. You've internalized it. Then you can't forget. Because it's caught you. It's got into your molecular structures. It's got into your cell. Right? But of course, those were the fundamental building blocks that were built with a certain rationale in mind. Those rationales also change over time. So the contract was about morality, personal morality, about autonomy that I undertook to subject myself to these terms in the contract, and now I'm bound by them. But today something called economics took over, especially in the United States. Capitalism took over, and the moral component became less and less, and the economic component became more and more. So I come to you and I say, I will sell you 5 mangoes, you give me 100 rupees. So you give me 100 rupees, and I tell you, sorry, I can't sell you the 5 mangoes. Why? Because he offers me 200 rupees. I say, I don't care, I'm not going to give it to you. You go and sue. You go and sue. When he goes and sue, what do I tell the court? I can return the 100 bucks. Can the court specifically order me to specifically perform? Only in some limited cases. The economists told the courts, and the law and economics scholars told the court, no. Don't insist on this mango shift. This is better off for society because I'm getting better value now. Now it is, where can I get better value from? Please protect the better value, because economically this makes sense. I get 200 bucks, I'm better off. And he gets his 100 bucks back, he's no less off. Just like getting mangoes. It's called the theory of efficient breach. I can efficiently breach this contract because I'm under no loss. I can pay him 150 bucks. I was ready to pay him 150 bucks more than what he gave me for the inconvenience that he was put to. I'm happy because I'm still making 50 bucks extra here. So the whole moral component is out of the window now. I'm not held to my promise. But now there's an economic theory of the economy and what suits us better. So that drives contract now to a large extent. That has been driving tort law as well. So the rationale somewhere, and of course there's a pushback. There are philosophers and legal jurists and people who come at it from a moral philosophy point of view said this is not the way to go. These were not why these regimes were built. We need to go back to these principles on which these principles rested, which rested on ethics. And if you look at Donahue as well, there's a strong ethical component, right? And you see that coming here, what he expressed rightly. That how can the law not help here? It's against equity, it's against good conscience. Somebody is getting away with murder, effectively. If we let them get away with it, then consumers are ruined. And consumers typically will not have the monetary and the financial wherewithal to take on manufacturers and big corporations that sell you these products. Right? So we need to find a way in which we can support the poor guy, support public welfare, support public health. There's a public health issue also here. By pinning liability. It cannot be that the law leaves you without a remedy, right? And you see that in Atkins. Atkins says it 2-3 times. Says that a law that leaves you without a remedy is no law at all. And you have the old Latin maxim, no? Ubi jus, ubi remedium. Where there's a right, there must be a remedy. You change it slightly, so where there's a wrong, there must be a remedy. So is it judicial legislation? Oh, we can make an argument both ways. Nobody will know. It is. I think it is. But should judges legislate? They have no choice. The English language is limited. The number of things that even a statute can provide for is limited. You cannot anticipate in advance all the situations that will arise. And you will always be on the thin line between making a new norm and adhering to an old one. Justice Nariman does it beautifully in a judgment on POSCO. Are you familiar with POSCO? Prevention of Child Sexual Abuse. But there's an interpretation of who's a minor. Go back and read it. It's a huge, he gives pages and pages on theories of statutory construction, what the judge's role is. Cites to some American jurists, Harvard Law Review articles, on whether you can fill the gaps, you can fill the, what do they call it, the interstices. They can only fill the molecular interstices. The theory of legisputation, I think that's what he called it.